All right, everybody, buckle up because we're diving straight into another wild day inside the courtroom. I'm breaking down every move, every reaction, and every decision the judge makes so you can see exactly how justice plays out in real time. Let's get into it.
Hi, yes.
Judge, I'm approaching on Mr. Perez. This was a case from yesterday, but it was rolled today. I unfortunately wasn't able to get back here in time to approach on PC.
Really, we're happy that you made it. So you said Perez, right?
Yes, Judge. Jorge Perez.
You're Jorge Perez?
That is Jorge Perez.
Mr.
Yes.
Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So correct me if I'm wrong, but he was out on bond on this case, right?
Judge, I'm not.
Yeah, we gave him a general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back. And when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant. We revoked the bond. You ended up going back to jail and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually approaching on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault. Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
The GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB.
Correct.
So you don't think they're PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Standard field sobrieties were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was red and the defendant considered a breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. So what's your argument?
So my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes,
The
Judge.
stop was initially because it's a prohibited vehicle, right?
Right.
You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to the DWI, Judge, I mean, he asked him to do SFSTs. He conducted those and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, .065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a .08 at the time that he was driving without any type of scientific method or any type of legal or actual scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a .08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial.
Yes, sir.
I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 6 out of 6 HGN, 4 of 8 walking, turning, 3 out of 4 one-leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you know, you may be right as far as they may, you know, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, what, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, you know, it coincides and
Just to understand, I have to wait 30 days to set it, or I
no,
can?
no, no. You know,
No.
let them know now so that they can get their ducks in a row as far as subpoenas and all that, you know, and is the breath, is what discovery's in.
Yes, and it's completed, yes, you have. We're just missing station video, but everything else.
Okay, that's a big part, you know, because you're gonna need that as far as breath testing and stuff. So, I mean, just stay on top of it. If you want to set it now,
Yes, Judge.
and if you want us to get it a couple of weeks, just to see if you can get the video,
I think
whatever you want to do.
Judge.
Okay. Yeah. Hi. Good morning, Mr.
I
Lee.
have Mr. Khalifa. He is in custody. And
Okay, right?
yes, with the K.
How's Mr. Khalifa?
He is, you
I like
know,
him. It's just,
he is very adamant. Say that.
yeah,
So
it's an understatement, right?
his felony attorney, I actually know his attorney that's on his felony, and he was here this morning. And I was talking to the chief, and you know, at this point, it would be time to set these for trial.
Okay,
And
it's up to you.
the
I mean,
they're asking for 2 weeks to talk to felony to see if they want to dismiss it. But if it does go to trial, I'll need an Arabic interpreter to review evidence, and I think also.
are there videos? Hold on a second. Whoa. Have you looked at the discovery?
Yes.
Is there stuff in Arabic?
Yes,
There
there's
is stuff in there.
Okay, so you got to go get all that stuff. That's a, hey, they're saying some of the videos are in Arabic.
For the text, the
Right.
text.
So-
Needs a prosecutor.
Remember, we need at least 45 days just to translate that video into Arabic.
Right.
So get on it now. Are you going to go to trial on this thing?
If they don't dismiss it, I am.
Okay, so can you send it to you need to transcribe it in Arabic. That takes at least 45 days.
Right, and we just have one ADA in our office that speaks Arabic and he has his own document.
No, but they send it out. But you got to put in the order now,
Yes, sir.
if you don't mind, please. Okay, so,
Right. If they don't dismiss it, we have no reason not to go to
yes,
trial.
hey, look, what I'm saying, let's get the order in now.
Exactly.
Because it takes 45 days. That's why.
Well, they may dismiss, but I don't know.
I know May is a big, you know,
I understand.
I want to make sure that gets done so he doesn't languish in custody because
Exactly.
we can't go to trial until that video is
Well,
transcribed.
no bonded on his felony, and that trial date's October 9th.
Of next year.
Well, this year now, 2025. Yeah.
They set a trial for October of this year?
And he has no bond in the 179th. So,
I have a trial in October, so go on felony. It got set last month.
should we just get a trial date out, you know, maybe 2 months?
No. I mean, let's just make sure the stuff gets done. Because when you set stuff out that far, they tend to not look at it because they're just so busy. It's better to just keep little settings so we know that we can get on
Could I
top
do
and
like
stay
a
on top of it.
2-week reset and then we'll,
Yeah, you want to eval it too?
Yes, sir.
Yeah, set it 2 weeks, eval it.
okay.
And then if it's good for you, start putting the video in to get transcribed. Because he says he's going to trial unless you dismiss it. So, yeah, okay? All right. For sure. Hi.
Need to get more Arabic speaking cases.
That would be an interesting case.
Yeah.
Yeah, anyways.
All right, Your Honor, I got Mr. Kabir, who's in the boxes for BVR. I have a feeling you're gonna want to raise bond or do something, so
Come on, Mr. Kabir.
if you were leaning towards that, I would like to request a hearing and have a record on it.
Sure.
But that's only if you want to raise. I hope you don't.
I mean, he tested positive. I've asked him not to use. I've asked him not to consume anything illegal. I've asked him not to consume alcohol. He's still using, you know?
Your Honor, it was, I spoke with pretrial, if, just hear me out for a second.
Sure.
Spoke with pretrial, it's presumptively for THC. You know, things like Delta 8s, kratom, hemp, those are all legal.
I admonish him over and over. This is our third bond violation. If I let him go, I'm enabling the behavior and I'm saying that it's okay to happen. It's a third bond violation, Mr. Kabir. I'm setting you for a hearing in 3 days. You must be here, be ready to go forward. Do you understand? I can't continue. It's a third bond violation. It's unacceptable.
Understand. And look, I appreciate you giving us a little time for the hearing. I was here yesterday as well. We are looking like, it looks like we're about ready to set this for trial anyway. Do you want to wait till the hearing?
If you want to set it, you can, but I'm requiring his presence in 3 days here to have the BVR hearing.
You said 3 days or 3
3 days. No, 3 days.
3 days.
So that you can get all your ducks in a row, get all the evidence you need. State, get ready, please, as well.
Yes, Judge.
But, you know, if it was a first, we admonish. Second, sometimes, okay, we're now at a third time.
Yep.
No. Yeah, okay, I'll see you in 3 days. Ray, how are you, man? A lot of drama today, man. A lot of drama today.
It seems like it. Want to add more to it?
Okay, it's okay. We still love you, Ray.
Yeah.
What you got?
Gomez, apparently it's O'Deer, Gomez, Santa Maria. It looks like they filed a BVR yesterday for tamper back on the 14th. His appearance was waived today. I didn't get this, so I didn't know to have him here today.
That's okay. So why don't we set it? You want to set it for Friday?
I have a CLE on Friday, so if we can do Monday, that'd be great.
Perfect. Yep, just let him know he's got to be here Monday. If he fails to appear, the warrant issues.
Sounds good.
Yeah.
And that's all I got.
Okay, have fun.
Thanks.
Santa Maria or Gomez.
I think this.
Morning, Your Honor.
Ray,
May I approach? I'm doing well. How about yourself?
does your guy have a BVR too? Yeah.
Sarah Castillo, Judge.
What's going on with that?
On December 31st, it looks like she reported for
Positive.
positive for alcohol.
Is she here now?
She's in the box, Judge. This is a single violation.
Come
Judge.
up, Miss Castillo.
It's the first time we've ever had any issue with her.
So-
We'll say I talked to her right after she learned that she tested positive. She sounded really sick. She sent me pictures of the NyQuil that she was taking that had alcohol. And Judge, I'm not gonna sit here and insult your intelligence and try and say that that's what it was. I'm
So, look.
not gonna do that, but.
If you ever test positive again, I'm now amending your bond conditions to put a leg monitor on you so I know that you're not consuming alcohol. If you ever test positive again, I don't care what it is, I don't care what anyone told you, you know and you should know what you're putting in your body. I don't care what the excuse is. But if I find that you test positive, you have any more bond violations, I'm going to lock you up. That's it. Do you understand? Okay, so I'm amending your bond condition, put a SCRAM on her ankle now, and I'll pay for it. Yeah. I want to make sure she's not consuming. If after a while she's not using, then we can talk, but I'm not going to take her word for it. We did that now. And where did it get us? So now I need more physical proof that she's not going to use. So now you're going to have a very cumbersome ankle monitor. You're going to have to explain to everybody what it is. Hopefully you get that. But court orders are court orders. And that's it. You're supposed to follow, and you don't. There are dire consequences. The next time, you're going to stay with me. You understand? Okay? Here we go. I'll pay for it.
Okay.
And then here we are.
All right then.
All right, cool. So we'll just do a normal setting, whatever you want, you know? Sure, yeah, absolutely. But
We're able to sit down and go through.
understand, it's no tolerance at this point. If I get another positive, if you fail to charge it like you're supposed to, if the battery goes dead, so does the bond. You understand? Okay? All right, Colin. Good luck.
Very clear, Judge. Thank you.
All right. Please.
Right this way.
Want to have PC read on case of 24, please?
Absolutely. Who is it?
Mr. Armand Jones, Your Honor.
Where's Mr. Jones?
Custody, Your Honor.
Please.
Yes, Judge. On February 2nd, 2025, officer on patrol on Greens Road at a business called The Spark at 1:36 a.m. and observed two individuals standing outside the front door. The officer initiated a consensual conversation with the defendant and the other individual, and while the officer was speaking with them, the officer observed a clear plastic bag inside the defendant's hoodie pocket containing a green substance in plain view. The defendant stated he had marijuana in his possession, and the officer retrieved marijuana and search incident to arrest found marijuana on the defendant's front jean pocket. The officer knew the substance was marijuana based on training experience, and the marijuana weighed 18 grams.
I mean, I get that he's just going up to a consensual conversation. That's something that they can do. He doesn't have to. He can just walk away. He's not doing anything wrong, but he decides to stay. And the problem is the officer says this is in plain view. Do this. Get the video if there is one. If the video shows that it's not in plain view, come back.
Sounds good, Your Honor.
But the fact that he's saying the plastic bag is out, it's in plain view, and he sees the weed, you know?
Fair enough, Your
So get the video. Like I said, if it doesn't show it's in plain view, come back. Redo it.
Thank you, Your Honor.
Absolutely. We have so much history with Mr. Jones. We have so much history with Mr. Jones. Oh,
Yeah, I saw it.
the same.
I saw it.
You know, this is probably number what? Like at least 12 or 15?
Yeah, we just went over it. I got it. Thank you,
So,
Your Honor.
so he's got the 2 felony cases. He's no bond. They're set for the 6th. Whatever you want.
Thank you, Your Honor.
Yeah, absolutely. Mr. D,
Yes, sir, Your Honor.
Hey.
Please.
how are you?
Yes, sir, Judge. I am here on Mr. Joshua Connor. Judge, this is an old case. It's a 2024 case. But Mrs. Burnell informed me that because the case is still old, that I need to approach you to see how.
So it's 400 days. On January 2nd, it was 2 weeks THA clear trial.
Yes, sir.
We appointed you to it. We're now in February. So what do you guys want to
I
do?
appointed this morning.
Oh, you just got appointed this morning? Okay. Mr. Connor, come up. So,
I don't think so.
hey, Alex, will you run an NCIC to see if he has any prior DWIs, please?
Looks like no prior DWIs, Your Honor.
Your case is 400 days old and it's time to make a decision on what we're going to do. I gave you a lawyer today because I'm not going to sit here and wait for months for you to try to go get a lawyer. It's time to make a decision now. I'm giving you 2 weeks from today to make a decision, whether you want to accept a plea bargain agreement from the state. If you do not, within the next 2 weeks, I'm going to immediately set your case for trial, and I'm going to give you an extremely quick trial setting. Do you understand? It would behoove you to meet with Mr. Dixon as soon as possible. All the discovery is in. I will give you no more resets after this time. Do you understand? Okay?
Thank you, Judge.
See you in 2 weeks.
Right this way.
Get ready for Friday, Dick.
BVRs?
We're gonna have probably like 10. Ready? Yeah, come on in.
So I'm pushing on Calvin Douglas.
Okay.
Yes.
I think I've been told that a dismissal has been filed.
I don't know.
Yeah.
I haven't seen it, Judge, but can I ask the state what, can I ask the state what,
Yeah, I'm signing it right now.
it says on there? Was it just,
Insufficient evidence of defendant's guilt.
okay, just because of the same reasons I'm opposing the continuance, Judge, I've got to ask for dismissal with prejudice on this one. Because if the state comes back and refiles, it would be the same effect as.
I don't know. I don't know how I can really, I mean, all I'm gonna do on all I do,
Right.
I sign the dismissal. I can't dictate on how
You
they,
could refuse to sign it and,
I'm not gonna do that,
okay, Judge.
I'm not gonna
I've got to ask. Thanks, Judge.
for sure.
Thank you,
Mr. D.
Judge. Yes, sir, Your Honor. I am here on 2 clients. First of which is Edward Burton. He was taken into custody because of the violations of the confirmed drug use. However, I don't believe that was a bond set, and I was wondering.
Oh, yeah. I'll do 2501.
2501.
Correct.
Yes, sir. Secondly, is Gerard Jones, whom I understand also tested positive, and correct me if I'm.
no-show.
He was a no-show, did not show up for. the
Right,
drug.
so I'm going to revoke both of those and then,
Yes, sir, Your Honor.
do you want to stay on or do you want to get
Yes,
off?
sir, stay on, stay
Stay
on.
on? Okay, okay.
And that wraps up this hearing. If you're into real courtroom moments, smart legal breakdowns, and raw reactions, make sure you tap like and subscribe. I've got plenty more coming. Stay sharp, stay curious, and I'll see you in the next one.